Good morning, everybody. Thank you all for joining us. We are going to wait just a couple more seconds until everyone makes it in, excuse me, from the waiting room. And then we will go ahead and get started. Well, we're going to start like we do every week with some Zoom housekeeping tips. So thank you again for being here today. I know it might feel like a tough day or a great day, depending on your perspective in the world today, but we're glad that you're with us regardless. And starting with the Zoom housekeeping that we tell you guys about every week, we are going to ask that you stay muted unless you would like to unmute yourself to ask a question. And your Zoom toolbar for finding things like the mute button or your start and stop video button is probably on the bottom of your screen, depending on what kind of device you're using. The chat bubble might actually be flashing because I did just put a message into the chat. And the message tells you how to put your questions into the chat and also where to email them if we either don't have time for them today, or if you think of a new question that you would like us to cover for next week. You can send those to info@condolaw.net by 4 p.m. on Monday so that we can include them on our list for that week's Wednesday Q&A. The chat is the best way to ask questions today or to request us to clarify something that we've talked about. But as I did mention, you are welcome to unmute yourself to ask a question in real time if you feel like you want to do that for any reason. But again, like I said, otherwise, please do stay muted. I think that is all I've got for Zoom housekeeping tips. So then I'm going to jump to a reminder that we are not here to give legal advice. We are here just to discuss general legal information that is helpful and relevant to community associations in Washington state. So what that means is a few things. Number one, if you send us a paragraph or 2 or 3 with details and bullet points and excerpts of your governing documents, you're probably asking a question that is too specific for this forum and we're not going to be able to answer it. When that happens, we let you know. Chelsea will send you an email. Don't shoot the messenger. I'm the one that says they're too specific, but she'll send you an email letting you know that it is too specific for us to cover in the Q&A. And when we can, we'll try to pull out a general topic or two from that specific email to try to cover more generally if we think it's broadly applicable. The other thing that this means, the disclaimer, I guess, is that if somebody sends you a copy of one of our Q&As or a blog article or copies and paste something from the chat in our Q&A, and they try to tell you that you have to do something or you can't do something because of something we said here, you can ignore them. Because they might be right, they might be wrong, I don't know, but this is not legal advice, right? The only person that can give you legal advice for any particular situation that you are facing in your communities or in one of the communities that you manage is the association's attorney. And the reason for that is because they are familiar with the specific governing statute for that community, the specific governing documents for that community, and the particular set of facts that you're dealing with in any given situation. So just keep that in mind. By the same token, the chat function, as I said earlier, is to ask questions or request clarification, not for, legal commentary or argument like sometimes you see on the CAI message boards. So please keep that in mind. We continue to receive a lot of questions about the Corporate Transparency Act and the reporting requirements that are going to go into effect on January 1st of 2025. Excuse me. We are going to start our Q&A today with a few questions about the CTA. So if you have a question about the CTA, please put it into the chat now, because once we're done with those questions, we're done talking about it for this week, because we've spent copious amounts of time over the last, say, 4 to 6 weeks in our Q&A talking about the CTA. And I think everybody's getting a little sick of hearing about it. And I know we're getting a little sick of talking about it all the time. But I will remind you of a couple things related to that. CAI did lose its initial court motion, its initial motion for the injunction, delaying the implementation of the CTA with respect to community associations. So at this point, we are telling our clients, and we are recommending generally, that all boards should plan to comply by December 31st of this year at the latest. So the deadline, the way the statute is written, it says you have to comply, you have to file your BOIR beneficial owner information report by January 1st of 2025. Sorry, before January 1st of 2025, which I think is confusing. So December 31st is the deadline for you to get that done. As I did mention, we've talked about the CTA a lot recently. So if you still have questions, either after today or some that come up in the next week or two, go to our YouTube channel and look at our videos for the past 4 to 6 weeks. And you will be so sick of the CTA when you're done listening to those videos. You'll know as much as we know. But I think the bottom line is everybody needs to comply, and it's not that big of a deal. I'll go into a little bit more detail on this when we start the questions here in a minute, but everybody needs to comply with it. There are almost no associations that are exempt. Certainly none of our clients that we're aware of that are exempt. And it's not as big of a deal as everybody is making it out to be. So moving on to a couple of other general announcements or reminders, we have been telling you guys, and we're going to keep reminding you that you need to provide enough time to get your budget ratified before the end of the year if you want to raise your dues on January 1st. The statute requires 14 to 50 days notice of a budget ratification meeting, and we are rapidly approaching the holiday season. And all of the managers that are on this Q&A today are like, girl, you are not telling me anything I do not know, because you guys are all buried under piles of budgets, so you know this already. But for any communities that haven't already thought about this, that might still want to raise their dues on January 1st, you want to get that budget ratification process started so you have time to hold your ratification meeting before January 1st. Because if you don't do that, then you can't raise the dues on January 1st. You can't, hold the meeting in February, but raise the dues in January. And the last announcement or thing that I'm going to remind everybody about is we are going to be starting a new legislative session in Washington in January. And in anticipation of that, the Legislative Action Committee through WSCAI is hard at work already in the off season, negotiating, for example, a trailer bill that will make some changes to Wakiowa as it exists now, which will be applicable to everybody in 2028. And the LAC publishes emails called the Monday Morning Minute that give you kind of a snapshot update of what's going on the legislative side of things. And if you signed up for it last year, you need to sign up for it again this year. Unfortunately, the list essentially purges and renews every year. And so I put a link into the chat. If you click that link, you can go sign up for the Monday Morning Minute emails. And that will be a way for you to stay informed about what's happening in Washington State at the legislative level, including things like sometimes we need homeowners or managers willing to come testify at hearings, which mostly can be done via Zoom anymore. So it does not require a trip down to Olympia in person, which is really nice. But the legislators, they don't want to hear from the lawyers on the LAC. They're really sick of hearing from us, I think, on a certain level. And the impact of homeowner testimony, and in certain cases, depending on the topic, manager testimony, cannot be underestimated. And so when we send out the Monday Morning Minute, if there's an upcoming hearing at which that kind of testimony would be helpful, you can find that information in the Monday Morning Minute. So please consider signing up for that. And I think that's everything for the announcements. So Lisa, unless you have anything else.
I just want to let everyone know that Chelsea's not here today. So Katie is helping out. So if you have a question you don't want publicly in the chat, you can send it directly to either Valerie, me, or to Katie, and she will help monitor that.
Thanks, Lisa. Okay, so I'm going to start with the question that's in the chat. When a person is elected to the board, is there a time limit for complying? Yes. So every existing community that is incorporated with the Secretary of State, which is most of the community associations in Washington, but not all of them, is required to comply with the CTA by December 31st of 2024. If you're a new community that was just recently incorporated in 2024, you have to comply within, I think, like 60 days of your incorporation. But most of you are dealing with communities or are living in communities that have been around for longer than 6 months. So pre-2024, that means you have to comply by December 31st, 2024. Going forward from that, if a new board member is elected or any beneficial owner information changes, you have 30 days from the change to file an updated report indicating that change. And for any of you who have done Secretary of State filings where you either incorporate an association or then you just do the annual report and like change the board members so that the correct board members show up on the Secretary of State website, the process is very similar. It's easy, straightforward, and not time consuming. So 30 days from the change in order to update the report. So I'm going to jump to the first question. We have 3 questions about the CTA. And so I'm going to remind everybody that if you have other questions, speak now or forever hold your peace, or at least for the rest of the hour, because once we get through these, we're not coming back to the CTA. We have an HOA that is not incorporated. With the new Corporate Transparency Act, our HOA is still going to be able to maintain unincorporated status. Secondly, if they are unincorporated, does that mean they do not have to complete the CTA requirements? So the short answer to this question is, if your association is not incorporated through the Secretary of State, it is probably not required to comply with the CTA. However, both Wakaiowa and the new Condominium Act require that all associations be incorporated. So if you currently are subject to either one of those statutes, you are required to be incorporated at the state level. And also, Wakaiowa is going to be applicable to everybody starting January 1st of 2028. So this answer that if you're unincorporated and you want to stay that way, you don't have to comply with the CTA, that's a limited time answer only, and it will change once Wakaiowa for all becomes applicable on January 1st of 2028. So the details for those that are interested in them is that under the Corporate Transparency Act, there are 2 types of reporting companies, and only one of them is relevant for our purposes because the other one is foreign corporations. And for our purposes, it includes corporations, limited liability companies, and any other entities that are created by filing a document with the Secretary of State or any similar office in the United States. So there is, if you go to FinCEN's website and you look at like all the exemptions that exist, it'll become very clear, especially if you look at the FAQs, that homeowners associations, condo associations are nearly never exempt. So if you are sitting there wondering, well, you know, maybe our community is exempt, I wonder if we are, the answer is probably not. As I mentioned earlier, I don't know that we have a single client in our office that is exempt. And we've been around for 20 years and represent probably thousands of associations at this point. So I think the chances are very good that your community is not exempt from these reporting requirements. So going back to the question, if you are not incorporated and have never filed a document with the Secretary of State to create a corporation or an LLC for your community, then you probably are not subject to the CTA's reporting requirements. But if you are either governed by the Condominium Act or Wakaiowa, you probably should get incorporated because your statute requires you to. And in that case, you then would also have to file a CTA, a BOIR, a report to comply with the CTA. Did you want to add anything to that one, Lisa, before I keep going?
Nope, keep going.
Okay. Next question. Last week, Ken said that non-voting board members do not need to be included on the CTA's beneficial owner report because they don't have control. Would it make any difference if the non-voting board member is the treasurer or the president? So I think that it's helpful to go back to the definition of who is considered a beneficial owner. A beneficial owner is anyone who owns 25% or more of the ownership interest in the corporation, or anyone who exercises substantial control over the company. Doesn't matter what you call the person. If they qualify under either of those categories, they are a beneficial owner, and they need to, you need to include them on your BOIR, your beneficial owner information report. Renaming a role on the board or stripping people of power so that they don't have to report is a bad idea. It's not something that we recommend. We rarely, not never, but rarely see documents that actually provide for an officer, such as a president or treasurer, who would also not be a voting member. However, I also would like to offer the comment that voting is not the only method by which an officer exerts power or control over a corporation. And I don't want to go to court and make an argument of first impression that my client didn't include this person as a beneficial owner because, yeah, they're the board president, but they don't vote, and therefore they don't exercise substantial control over the corporation. Because board members have power outside of their vote. And I don't mean that they have power individually to go out and just go rogue and do stuff. That's not what I'm talking about, right? But a board member can exercise influence in a community and power in a community, even outside of their vote. So I think it's really clear that I think two things are clear. The CTA clearly requires or contemplates that all board members would be considered beneficial owners. I think it's also clear the CTA was not created to actually target or address an issue in community associations. In other words, the fact that you all have to comply with the CTA, I think, is an unintended consequence of a well-intentioned statute that was created for legitimate purposes, and you guys just all kind of got swept into this. I don't think it was ever intended to specifically target community associations. I do hope that at some point in the future, we'll see an exemption so that community associations don't have to comply with the CTA, but that's not where we're at right now. Where we're at right now is we have a statute. It defines who is a beneficial owner. It defines who is and who isn't exempt, and you guys are not exempt. And so I would recommend to a client asking me this question that even if they have an officer on the board who is a non-voting member, the safe approach would be to include them on the beneficial owner information report. And in particular, because it is so easy to do that, I just don't see the value in not doing it. I don't see the return. What's the return on that investment, right? What's the benefit of excluding them from the report? And what I'll remind everybody about is what I've said multiple times in previous Q&As. It is really easy to address individual board member concerns about keeping their own personal information private, because the board members do not have to turn their private information over to your manager or to your board member filing the BOIR or to your vendor that's filing your BOIR. All the board member has to do if they want to keep their personal information private is get online, create their own FinCEN account so they can get a FinCEN ID number for themselves individually. Then they're only giving the government their information. And again, as I've said many times in the past, spoiler alert, the government already has that information. You're not giving the government any information they don't already have, right? They create their own FinCEN ID number, and then all they have to give to whoever is filing the association's report is the FinCEN ID number. That's it. So your confidentiality concerns are addressed completely. You're not giving your private information to anybody that does not already have it. And so I just don't see the upside of excluding a non-voting board member from the BOIR, and I see potential risk. So I would tell a client not to do this. Lisa, did you have anything you wanted to add?
I don't think so. I think this is all just so new that we don't know what the courts may, whatever may come out of future court action. So I think the safest thing at this point is to comply. And as Valerie said, it's fairly simple, and your information is protected.
Yes.
From other board members.
Yeah. All right. I've got one more question that we got in advance. Then I'll tackle the CTA questions that are in the chat, and then we're going to move on. The last question that was submitted in advance was, should boards let the community know about the CTA, what it's all about, and whether they've complied? I mean, I don't think you have to. I wouldn't say that you should avoid disclosing it, but all the decisions that you make about how to comply with the CTA should be memorialized in your board meeting minutes anyways, because somebody should make a motion that so-and-so files the report, and somebody should second the motion, and then you should vote on that, and the action should be recorded in the board meeting minutes. And if you want to know why, go back 3 or 4 Q&A videos and watch it, because I talked about how documenting your efforts to comply can be helpful if there's ever a question later about your compliance. So I don't think there's any reason to hide information about the CTA from your ownership, but I also don't think there's any particular need to proactively inform them, because it doesn't really impact them one way or the other. Lisa, did you have anything to add on that one?
No.
Okay. All right. There were a couple of questions popped into the chat about the CTA. If there is a master association and a sub-association, both of which are incorporated but using the same EIN number and budget, does the COA have to submit a BOIR if the COA members are members of the HOA board and filing under the Okay, that's too specific. However, what I will say is if there are two different associations that are incorporated at the state level, then they both have to file a CTA report. So I think all the other details maybe in the specifics in your question are sort of irrelevant. If you have the HOA that is incorporated at the state level with the Secretary of State and the sub-association condo association is also incorporated with the Secretary of State, they are both required to comply with the CTA, and that means they both have to file a BOIR. Next question. A unit has more than 25% ownership interest and has a married couple as owners. The spouse is on the board and has a FinCEN number. Does the spouse, the other spouse, I'm assuming, also need a FinCEN number? Yes. If they co-own the unit, they are both beneficial owners. I would have the second spouse obtain a FinCEN ID number and also include them on the BOIR. The next questions are not related to the CTA. So I think we're going to jump back into our questions that were submitted in advance. And then if we have time, we'll get to whatever else we can from the chat. Lisa,
Sounds
take it away.
That's me. Next question is it advisable to interact via email with homeowners or to have the property management company be the point of contact? And we talked a little, when we were preparing for this, we talked a little bit about sort of what was behind this question, I think, but the short answer is essentially do what you want and what works best for your community. As a board, you should have a policy or have a decision about how you want to communicate with your owners and what makes your community your community. It may, so you want to, you may have a communication policy that dictates how things go in your community. If there's an emergency, who to contact, if there's this, who to contact. But I think it depends on what you're talking about and whether an owner wants or expects emails or communications from an official like a board member to have it be a binding response. But remember, the board is only the board when they're at a board meeting. So an owner emailing someone outside of school, for example, isn't necessarily going to get an answer that is binding on the association. So back to the short answer, it sort of just depends. It depends what you want. It depends partly what your agreement is with your management company. And that stems from what the board wants as its communication persona, I suppose. I think as a practical matter, it is often simpler and more efficient to have the property manager be a point of contact for a lot of things. They can then put those things on the agenda for the board to discuss at a board meeting, or if it's a simple question, where's the garbage can, when's garbage pickup, that kind of thing. It doesn't necessarily need to be the board that's involved in those conversations or decisions. But again, this is your community and you get to decide how you want to communicate with people. So I don't think there's a right or a wrong answer. There may be a more efficient answer, and there may be an answer that makes sense in certain situations and doesn't in others. But I think we often help associations and communities with communication policies, and that really sort of sets out the guidelines for what your community looks like and how you want things to go. That may be somewhere to start if you're having problems with over communication, for example, from an owner to spamming board members that don't need to be on emails. Valerie and I talked a little bit about there are boards that ask, they want to be on every email that a manager is on with an owner, and that's their prerogative. But I think the answer is it's up to you to decide how you want your communication to be with your owners. There isn't a right or a wrong answer. Anything you want to add to that, Valerie?
Yeah, the one thing I'll add is, the size of our communities that we all work with varies really wildly. And so a board of an 8-unit condo association might feel one kind of way about having every owner possess their email address. And a board of a 300-unit condo association or a 3,000 home HOA might feel very differently about every single owner being in possession of the board email addresses. So I think that's part of why there isn't a one-size-fits-all answer to this question, because not only the size, but also sort of the general approach to governance is going to vary by community. And we think the most important thing is that whatever way you want your owners to communicate with you, you got to communicate that to them So don't hide the ball, right? Make it easy for your owners to understand how best to contact the association.
Okay. Next question is also me. I have a question regarding the applicability of the Servicemember Civil Relief Act. The owner was sent violation notices and fines for failure to maintain their landscaping. The owner is refuting the fines and wants and needs to correct the violation, but they are on active duty deployed on a ship and is citing the SCRA Act giving her protection. This person did a little research, and it seems that the act protects service members from foreclosure or default judgment, but not having to maintain their property in accordance with the HOA rules. Is there something else we're missing here? I'll give you the quick short answer, and then I'll kind of go into what the SCRA is a little bit, just for those of you who aren't familiar with it. The shorter answer is this person who asked the question is correct. It doesn't apply to fines, property maintenance obligations. It is limited to financial issues and foreclosure related problems. As a practical matter, finding someone that you know is deployed is not really going to prompt compliance, and it doesn't look great. So you want to ask yourself some questions about whether or not, as we've said before, do you want to be the association on the news? And not in a good way. To go back to what the question of what is the Servicemember Civil Relief Act, those of us in collections deal with the SCRA fairly regularly, because what it does is it applies to active duty service members. It also applies to reserve duty service members who are when they are on active duty. There are a lot more descriptors, but that's the basic type of person this applies to. There are several things that it offers protection for those people. The things, as the questioner pointed out, that are really relevant for us are that it protects a service member from someone taking a default judgment against them if a lawsuit has been filed, and it also may require a creditor to pause a foreclosure action. So, as I said, we will run what is called an SCRA check, or a Department of, again, DMDC check, which basically looks to see, is this person on active duty right before we request a default judgment in a foreclosure lawsuit, and then also before a foreclosure is held. You want to make sure someone is not overseas on a ship and has no ability to defend themselves. It's a practical rule, really. If you think about it, how is this person supposed to defend themselves if they are not in country or able to respond? And as my short answer pointed out, it has nothing to do with fines. It has nothing to do with upkeep of property, those kind of things. But as I also alluded to, I think it is important to think about how your association wants to communicate and how they want to present themselves in relationship to this overseas service member. And you may want to consider giving them some leeway. It doesn't say that they don't have to comply with the CC&Rs. It doesn't say they don't have to comply with the rules. But I think you may want to communicate with your other members, with the board, and decide, is there something we can help with this service member? And it may be that the community wants to dive in and help them out. And it may just be that you put this in abeyance until they are back home and able to comply with the things that they are able to comply with. It doesn't sound like this person doesn't want to comply. It's that they're just practically saying, I can't do it right now. So it may just be something that you as a board want to talk about, how you approach this member and whether the community wants to get involved and assist. You're not required to, but again, it's one of those things that you kind of want to look at. How does this look? What's the sniff test for this? But you're right, the SRA doesn't protect this owner from those fines being put in place. Valerie, anything you want to add that I missed there?
I just want to emphasize what you have already said. If this person is deployed on a ship, how are they supposed to mow their lawn? And contrary to what some people believe, our service members are not always paid super generously. And so, one response might be, well, she could just hire somebody to mow the lawn, and not everybody has the financial means to do that. So I would just be really careful about how you handle enforcement issues anytime you're dealing with someone who is deployed in our military. I would check with your association attorney before you take any action. And one thing that I would tell a client in this position is, why don't you just mow the lawn yourself? I mean, if you have landscaping services coming out to the community anyways for the common areas, and it would, add $20 to their service fee for them to mow this person's front yard, mow their front yard. Or as Lisa mentioned, perhaps there might be other people in the community, a neighbor, for example, of the service member, who might be willing to do it for them in recognition of their service to our country. So it's something you want to be really careful about for a lot of different reasons. And that all those comments are not relevant to the actual SCRA part of the question. So I'll leave it at that. Our next question is this: a homeowner has volunteered to be a board member. The homeowner is going through a Chapter 7 bankruptcy with unpaid HOA balance listed as a debt and potentially their home going into foreclosure. Is it considered unethical or a conflict of interest for the homeowner to be a board member? So there's a lot of different sort of nuanced issues that are raised by this question. One is whether your community can allow someone who's delinquent in payment of their assessments, for example, to serve on the board. And unless you're a Wakaiowa community, the answer to this lies almost exclusively in your governing documents. The other statutes do not set a requirement that board members be in good standing on their assessment account in order to serve on the board. And if the person runs for the board and is elected by the ownership while they still own their home, then I don't think there's anything per se unethical or conflict of interest related about their service on the board. There are other, I have other concerns about this situation in general, right? Board members are required to act in the best interest of the association. If, for example, a board vote came up that was related to this particular owner's bankruptcy or delinquency, I would want that board member to recuse themselves from any involvement in that decision, obviously, because in that particular scenario, there would be an actual conflict of interest. I also, as an aside, this is completely unrelated to the question, but I would like to remind everybody that while bankruptcy discharge affects a person's personal liability to their association for their balance due, whatever balance due is discharged in the bankruptcy, it does not affect the balance of the association's lien against their property. So if you haven't already talked with your association attorney about this owner's bankruptcy and what the association might want or need to do to protect itself with regard to the balance due, I would recommend that you do that. So to the question itself, you need to look to your particular governing documents, in particular your CC&Rs and your bylaws, to see if there is some documents will contain a list of qualifications to be on the board, or what it means to be a board member in good standing, or an association member in good standing who's therefore eligible to serve on the board. So you want to see if there's anything in there that might impact this particular decision in your specific community. But again, there's no statute that prohibits a delinquent owner from serving on the board, except for Wakaiowa does allow for removal from the board of a delinquent owner once they've been given notice of their delinquency and they have failed to cure the problem. This does require 2/3 vote of the board to remove that person. You want to be really careful though, because if you're sending them notice of the delinquency as your basis for removing them from the board, is that viewed as an action to collect a debt, which is barred by the stay in the bankruptcy? So I would want you to be really careful about how you would approach this, because there's not just sort of governing document and board service related issues here, but there are also bankruptcy related issues. And so I would just say, if you're dealing with this scenario in your community, consult with your association attorney so you don't step in a pile of something you don't want to step in. Lisa, did you want to add anything to that?
No, people are all different, and it's possible that a board member would be a fantastic board member who's going through this. It might be completely unrelated to their judgment, and they could put the HOA's interests first. And then there's other people who this wouldn't be easy for them to put all that aside. So like Valerie said, talk to your attorney about it, and it's really a case-by-case situation sometimes. Okay, next question. During the annual budget meeting, are minutes required to be taken? If so, what action can be taken by the homeowners if the board refuses to do so? Meaning if the board refuses to take minutes at the budget meeting. I don't know what section or what act this association is organized under. But if we could look to something like Wakaiowa 6490-445 subsection 3. It says minutes of all unit owner meetings and board meetings, excluding executive sessions, must be maintained in a record. The decision on each matter voted upon at a board meeting or owner meeting must be recorded in the minutes. There's also similar requirements in the records sections of the new act. RCW 6434 has a section that discusses that. And so I think the short answer to your question is probably they are required. But the second question is, what do you do if your board refuses to do something about it? And I think, as Ken has said in the past, sometimes it's just ask nicely. Have a homeowner ask nicely, could you please make sure that minutes are taken? Cite to the statute that you organize under or that requires your record section that requires minutes be taken. And that might do it. Maybe if the board is just informed they are supposed to take minutes that they may do so. You could also kind of take the nuclear option, as Valerie has said, and just call a special meeting and remove the board members who are refusing to do it. That's an option for homeowners. So, you know, I think you could also, I suppose you could always ask, if it's because no one wants to take the minutes, could you ask someone else to take the minutes who's not on the board and then maybe put it on at the next board meeting? And then keep in mind that a ratification meeting is not the same as other meetings, so there may not be a quorum at that meeting. So there wouldn't be minutes, but there might just be a record of what happens at that meeting. It could be as simple as the thing that you send out after the meeting to all the owners. It says the budget was not rejected, so here's the budget. That might be the record of that meeting. So keep in mind that might be all that is needed for that. But I think the short answer is they should be done. There should be a record of all meetings that occur. But what you can do to force your board to do that may vary. Valerie, anything to add to that?
I just want to emphasize your last point, which is because the question did ask about the annual budget meeting. And if we're talking about just a budget ratification meeting, and if there is no quorum, then minutes would not be the appropriate record. But a notification to the ownership that the budget was ratified and here's the amount of your dues for next year, that's a good enough record of what happened at that ratification meeting, right? Because at a ratification meeting with no quorum, the only thing that can happen is the budget either gets ratified or voted down. Well, voted down would almost certainly require a quorum, but anyways, right. So the quorum issue really is sort of what this question turns on. If there is a quorum and or if any other business occurs, there should be minutes. If there's no quorum, minutes would not be the appropriate record, but you want to notify the owners that the budget was ratified and what their assessments are going to be for the next year.
Right. And that brings up our other point is that you don't need a quorum for a budget ratification meeting.
Yes. Yep. All right. Next question. In your experience, are most condominium and HOAs in this state incorporated under the RCW 2403 Nonprofit Corporation Act or 2406? Do you have an opinion about which is more appropriate for an HOA? The vast majority of our clients, I would say like 2/3 of them probably, are incorporated under 2403. It's actually 2403A now. It used to be 2403. It might be more than 2/3 actually. A handful of them are organized under 2406. And when we were researching this question, Ken and Lisa were kind of chatting about it in our prep meeting. And I was Googling when each of these statutes was enacted, because in my head, I was thinking, well, one of them must have been around for a really long time. And then the other one must have come after, and there must be, significant differences between them. They were enacted within 2 years of each other in 1967 and 1969, which I thought was kind of interesting. And most of the organizational documents that we work with for our clients don't specify which one. Most of them will just say it's incorporated under the Nonprofit Corporations Act or statute. And but when we dig and when we do find a specification in the documents, I would say far more often than not, it's 2403A and not 2406. Interestingly, when you look to the community association statutes, the common interest statutes, Wakaiowa does reference a provision in the Nonprofit Corporations Act. And in that particular case, it refers to 24.06. That's in the Wakaiowa section about proxy notices and immunity from liability, I think. But the Condominium Act in a separate section talks about RCW 2403A or 2403 anyways. So it's interesting to me that we have these two nonprofit corporation statutes. I will say that for our purposes, for most of our clients, which one they're incorporated under kind of doesn't really make a huge difference, because for the sections that most often apply to our type of communities are very, very, very similar. There's a lot of overlap and a lot of similarity between the two statutes, and where they differ is usually outside of the sections that are most applicable to community associations. And I will also remind everybody that per the actual common interest statutes, both the Condo Act and Wakaiowa say this, that if there's a conflict between them, the common interest statute is always going to control. So we only end up looking to the nonprofit corporation statutes if our documents and our governing statute are silent on whatever the issue is that we're looking at. So all of that being said, hopefully that answers the question. I don't think one is per se better than the other. I think you're going to be fine no matter which one you choose to incorporate under. If you want to be incorporated under the one that is most commonly chosen by community associations, that would be 2403, but I don't think you're going to be hurt in any way by choosing 2406. I will jump to the next question. Under RCW 6490-525, is there any situation where a condo board can impose a special assessment or budget change without a vote of the owners? The short answer is almost never. Probably not is the short answer, unless you are a Wakaiowa community dealing with an emergency, and that is only with respect to special assessments that would not include a budget change. So I'm putting the section of Wakaiowa into the chat that deals with emergency, because the statute defines emergency really specifically. And what it says is, in this section, emergency means an event or condition or a state of emergency declared by a government for an area that includes the common interest community that constitutes an imminent threat to the health or safety of the public or residents of the common interest community, a threat to the habitability of the units, or a risk of substantial economic loss to the association. So this would not include emergency, and I'm using that term loosely, as many of our communities might like to try to define emergency, right? We have a lot of clients that will say, well, what about an emergency? Can we do this in an emergency? Can we do that in an emergency? And when we kind of try to dig deeper into what it is they actually think is an emergency, 9 times out of 10, we don't think it's an actual emergency, right? It might feel urgent, it might be really important, but emergency is a whole different thing. So the short answer is, under Wakaiowa, and frankly well, this is true for all of our communities because everybody is subject to the budget ratification section. It's unlikely there is any situation in which the board can impose a special assessment or change the assessments without a vote of the owners. And I want to dig into a little bit of a nuance here, because it says a budget change in the question. And I want to remind everybody that your budget is not, it's not like the 10 commandments etched into stone, right? Your budget is a planning tool. It is your best guess about how you're going to spend your money in 2025 based on how you spent your money in 2024, what reserve components might need repairing in 2025, how much assessment income you think you're going to get in 2025, et cetera. And you might put in a dollar amount for 2025 for, let's say, landscaping. I'm just going to pick something. And let's say in 2024, you spent $12,000 on landscaping. And so 2025, you budget $13,000 for landscaping because you're thinking, oh gosh, I need to put some cushion in there for inflation. But then all of a sudden, every landscaping company in Washington tells you it's going to be a minimum of $15,000 for your landscaping in 2025. That doesn't mean that you throw up your hands and say, oh gosh, I guess we can't have landscaping in 2025 because the amount that it's going to cost us is different than the amount that we budgeted. It means you're going to spend more in 2025 on landscaping than you thought you were going to. So your budget as a planning tool was imperfect in guessing the correct amount of your landscaping costs. But you adjust you adjust and you spend the 15K if that's something that you need in your community for the landscaping, and that money has to then, you know, come out of some other thing that you had budgeted for, essentially. So budgets are planning tools, but they are not accurate methods of predicting the future cost of every item you're going to spend money on as a community. So that's a distinction that I want to make, because the board does have the discretion to vary from the budget if the circumstances require it. What you can't do without a vote of the owners is impose a special assessment or change the amount of the assessments that the owners are paying based on that budget, simply because circumstances have changed. So what do you do in the middle of a year if something comes up? I just had a client contact me last year where there was a fire, not last year, last week, because there was a pretty big fire in one of their buildings. And it destroyed a couple of units in the building. And so now they're looking at, you know, they do not have a deductible shifting amendment within their community. They're looking at a pretty large dollar amount for the uninsured portion of the loss, because it's a per unit deductible of, I think, 30K. So they're looking at having to spend a whole lot more money on insurance deductibles than they had budgeted, right? Because you don't budget for those kinds of things. You never know when they're going to happen. So what can they do? What they can do, there's a number of different things that they can do. One of them is they can impose a special assessment by proposing one to the ownership and having a ratification meeting. And remember, at your ratification meeting, assuming you followed the steps correctly in the statute for ratification, your special assessment is going to be ratified unless a majority of the voting power in the community votes to reject it. You also could, in the middle of the year, propose a new budget for the remainder of 2025. It's a pain in the butt to do 2 ratification meetings in 1 year, but sometimes circumstances require these kinds of adjustments. The other thing that you can do is there are certain circumstances in which you can borrow money from your reserves if you have a plan for repayment within a certain period of time and disclose that to your ownership. So if you're dealing with a situation where you think, gosh, we need to do a special assessment, or we need to change the assessments, or we need to borrow money from our reserves, but we don't know exactly what our options are, what this looks like, just ask your association attorney to walk you through your options and what steps you have to take given whichever option you choose. But don't change the assessments or impose a special assessment without a vote of the ownership, because that's not enforceable. It's not authorized by statute. Lisa, did you have anything you wanted to add to that?
Just my, I don't know how many times a year reminder, please follow the correct procedures for your budget ratification so that Valerie and Tima and I can collect your assessments if an owner doesn't pay. If you have questions about that, you can email Chelsea at info@condolaw.net, and she could direct you to the primer that Valerie and Ken did on it, I think, a year or 2 ago, or you could just search our YouTube channel and it goes through how to ratify a budget if you need help with that.
Yep.
Okay, next question. A community did not have a quorum at the annual meeting for several years. We keep minutes to document this, but also to reflect budget ratification. Should these non-quorum minutes be approved in a year that we do have a quorum at the annual meeting? And this question kind of goes back to what we were talking about before. The short answer to this question is absolutely. If you have a quorum at a meeting and you've got records from prior meetings and you want to make a motion to approve them, go for it. But note that a meeting did not occur if you didn't have quorum. So it'll just be that you're making a motion to recognize the record, basically, so that a budget was ratified that year, or that something was discussed at a meeting. But the actual meeting itself, there weren't any motions. There shouldn't have been any action taken at a meeting where there was not quorum. So it would mainly just be to kind of recognize the records and put them into, to authorize them and to put them into the records so that everybody can access them later. But it isn't, because you didn't have a quorum at those prior meetings, there shouldn't have been any action taken. So it wouldn't technically be minutes we're talking about. So as we were talking about before about the budget, the letter that goes out afterwards, that's enough of a record that you probably don't need to do anything formal at a meeting where you have quorum. But there's no harm in making a motion to approve or to make a record of things that happened in prior attempted meetings where there were not quorums. I don't know if that's too confusing, Valerie. Did I miss anything there?
No, I think you covered it. I think you answered it perfectly. All right, I'm going to move on to our next question. This is a two-part question, and it is the last of the prepared questions. So we'll see if we have time to get to anything from the chat after this one. The question, so this was edited down from a really long, detailed question that we got from somebody who is in a community dealing with a special assessment for a pretty large repair project. And the question relates to an association trying to assist homeowners that cannot come up with the full amount of the special assessment that's going to be imposed. So what we did was we tried to take a couple of general questions that we could cover because we couldn't go into all of the detail requested by the full question. So part one is, what are the pros and cons of an association getting directly involved in providing loans or extended repayment plans to owners? So I think the pros are, where I would jump straight to is if your owners can't pay the special assessment all at once, but they could pay if there's a payment plan or an HOA loan. But the pro is that your owners are going to be able to pay where otherwise they can't pay, right? So the pro is not just that owners will be able to pay, but that owners won't necessarily lose their units because of their inability to pay, right? Because we take the sort of inability to pay to its logical end conclusion, and that is that there, a large delinquency arises, the association records a lien. If the owner fails in all of their options to try to get a way to pay the special assessment, then you are looking at the possibility of a foreclosure lawsuit, and that wipes out the owner's interest in the property eventually. So the pro is it facilitates more of your owners being able to pay, which A, helps them keep their home, but B, helps the association be able to fund the project more quickly than it would otherwise be able to do if there were large gaps in payment, and that meant you couldn't do all the work that was needed right now. So I do want to sort of tackle some of the differences here. An association can go to a bank, assuming it has borrowing authority in its governing documents. It can go to a bank and take out an HOA loan for whatever portion of the special assessment the owners are not able to pay. So let's say you have 100 owners in your community and 50 of them can pay the full amount of the special assessment upfront, but 50 of them cannot. You can take the full payment from the 50 owners that can pay and go get an HOA loan for the amount that's owed by the 50 owners that can't pay. And then those owners would enter into a payment plan with the association. Over time, the association would owe the money to the bank. And so some of the things that are that you should be aware of in considering this option is that the loan obligation is between the association and the bank. And the obligation to make the payments is not contingent upon whether the owners are paying their assessments to the association. So just like in a regular budget, we tell our clients, if you had 5% delinquency last year, you need to budget for 5% delinquency this year, meaning you got to pad your budget by an amount that's going to still let you pay your bills if 5% of your owners don't pay last year. Similarly, you want to budget or provide some cushion in your special assessment total so that if one or two owners are not able to keep up with the payment plan over time, you can still make the loan payments to the bank because the association is on the hook to the bank for that loan payment, regardless of whether the owners make those underlying payments. For association loans, it's important to note that banks don't do anything to check whether the individual owner is actually going to be able to make the payments to the association. So it's an unsecured loan from the association, or sorry, from the bank to the association. Well, it's not necessarily unsecured. It's secured by the association's right to collect future assessments from the homeowners. The bank does set maximums for the number of owners who are delinquent. And so if your delinquency rate rises beyond a certain amount, that can be considered an event of default when you are in that loan repayment cycle with the bank. So that's something to be aware of. The bank will look at the value of the units and the value of the bank and how the two correlate. And they will also look at existing delinquencies before you take out the loan to determine and evaluate whether the association can actually repay the loan. So like I said, the pros for getting an association loan are essentially that you spread the assessment out over many years, and it allows you to be assured of the funds now because you get that lump sum from the bank now. You can pay for the work that needs to be done, and then your owners are able to pay it off over time. In the special assessment or the payment plan amounts from those owners that are participating in the loan, you include the ability to recover the interest that the association is paying on the loan. So it's not that you're just eating the interest as an association and the owners are getting a free loan, right? So there is at least contemplation that over the life of that repayment plan, the association will be made whole when it comes to those interest costs. The cons for getting an association loan, I think, are probably obvious from what I talked about, including the association being on the hook for those payments, even if the owners default to the association. There are also some administrative costs and fees associated with ongoing special assessments. So if you work with a professional management company, we know some of them charge like a special assessment admin fee on a monthly basis to process the owner's monthly special assessment payment. And let's say that's $5 per unit per month. If you've got, like I said in our previous example, 50 owners who are participating in the HOA loan, and that's 50 owners times $5 per month times 12 months in the year, that's a fairly large cost associated with the special assessment and the HOA loan over time. So that's just something you would want to be aware of. And if you disclose it to your owners and it's included in the special assessment ratification information, you can recover that cost from the owners participating in the loan. You just want to make sure that you're making the required disclosures for that. We have a small number of clients who have had within their communities a small enough number of owners who needed payment plans that the association self-funded those payment plans. So rather than going out and getting an HOA loan, you know, if in the previous example of 100 owners, if only 2 or 3 of them needed a payment plan and you had enough money, for example, in reserves that you could pay for the project and then repay the reserves over time with the payment plan income from those owners that needed the payment plan, that might be something that was reasonable for your community. But again, that's something we only see in a relatively small percentage of cases. So related, the second part of the question is, if the association provides financing and an owner is not able to make the payments, does the association end up in the position of placing liens on the unit and perhaps having to foreclose? And the answer to that question is yes. If an owner is unable to make special assessment payments to the association, or if you enter into a loan agreement, like where you're self-financing the loan as the association and the owner defaults on the payment plan to the association, that is your recourse. Your recourse is that you go through your normal collections process, you record a lien, perhaps you send a demand letter. There is one resource available to homeowners right now that I think is worth mentioning, and we've talked about it before, but maybe not as much as we should have. Currently, Washington State is one of a handful of states in the country that still has money available through something called the Homeowner Assistance Fund. And this is a grant program that was funded through federal funding as a result of COVID. And homeowners who qualify can apply with a housing counselor for a half grant. And they can get up to $60,000 paid towards past due housing costs if they qualify for the grant. And so this would include if they're behind on their property taxes, if they're behind on their mortgage, and if they're behind on assessment payments to their community association. So that is a program that's available through the state right now. I don't know how much longer that's going to be out there, but if you have owners who are falling behind, even on their regular assessments, or for sure, of course, on a special assessment as well, there is a notice of delinquency that is currently required to be included with your first written notice to the owner that their account has fallen behind. And if you don't know what the heck I'm talking about, then send Chelsea an email at info@condolaw.net and ask her to send me the email, and I'll give you the link to the statute that talks about the notice of delinquency. The reason it matters is because the notice of delinquency contains the information for the housing counselors and other resources owners need to access the half grant application. So that's another resource that you can be passing on to all of your owners if they fall behind on their account. So I think I just saw the clock tick over to 11 o'clock, and I know we're missing at least one question from the chat. So if we didn't get to your question today, please email it to info@condolaw.net. Thank you all for being with us today, and we will see you next week. Bye, everybody.
Bye.